Court of Appeals, First Appellate District of Ohio, with the Honorable Jennifer Peterson presiding, is now in session. Please be seated.
Good morning. Welcome to the First District Court of Appeals. We have a total of 4 cases to be argued today. 2 are consolidated. The first case on the docket is C-25-0228, Mahoney versus Moskowitz. If the attorneys will please stand, state your name and the party you represent.
Michelle Stagnero on behalf of the appellant, ready to proceed.
William Alexander on behalf of Robert Moskowitz.
Great, thank you. The second 2 cases are consolidated, C-25-0096, Bates versus Durrani, and C-25-0097, Judkins versus Durrani. If counsel would please stand, state your name and the party you represent.
Philip Williamson on behalf of appellants, ready to proceed.
Good morning.
Alex Chapman and Bev Moran for appellees and the Durrani matters. Ready to proceed.
Good morning. And then lastly, C-25-0346, Clark versus Anguili. I'm probably mispronouncing that. If counsel would please stand, state your name and the party you represent.
Yes, Kimberly Beck from Beck Law Center for Alex Clark, the easier of the 2 names to pronounce.
Thank you.
And James Engler for defendant and Julie.
And Julie. All right, thank you. All right, we'll start with the first case, Mahoney versus Moskowitz. Would you
Good
like to
morning.
reserve time?
I would like to reserve 5 minutes, please.
All right.
Good morning. I would like to start by starting with the first assignment of error that I argued on behalf of Ms. Mahoney. This is, as the court is aware, a case out of the Domestic Relations Court of Hamilton County. One of the largest issues that was raised during the course of the proceedings was concerning the prenuptial agreement and its validity and enforceability. The trial court did find it to be valid and enforceable, and as a result, there was an inequitable distribution of the property based upon the terms of that prenup. The first argument we have is that we believe that that prenup was not valid, and nor should it have been enforceable. There were 2 issues I raised under that assignment. The first one being that the agreement was entered into with fraud, duress, coercion, or overreaching, as that term has been defined. And according to the gross court, if that happens, then the prenuptial agreement would be found to be invalid and not enforceable. With respect to the overreaching coercion part of it, there is a presumption that if the agreement is presented very close in time to the marriage, that it would include coercion or overreaching and therefore be invalid. In this particular...
There was evidence, though, that the parties had discussed it earlier, correct?
There was testimony from Mr. Moskowitz that there was some discussion. However, our position is Mr. Moskowitz's testimony was incredible and should not have been carrying any weight. And the reason I say that is because when he was questioned on details of things, he was not able, he would say, I'm not sure, or I don't remember. All he said was, yes, we discussed this. However, there was no evidence to show that my client had seen the agreement or discussed the agreement with him prior to seeing it in the car on the way to the ceremony.
So the trial court made a specific finding that Mr. Moskowitz was credible. Are you asking us to disregard that?
I am, and I think the court has the ability to do that under a manifest weight of the evidence standard of review. We're looking at the competency of the evidence before the trial court, and I think if you look at the testimony and look at the totality of the circumstances, you will see that his testimony was not credible for all the reasons I pointed out in the brief and in the evidence. And, the trial court did state, and I think the trial court did believe my client that she did not see the prenuptial agreement until it was pointed out to her in the car on the way to the ceremony. That's the way I interpreted the judge's decision. I think what the judge really focused on was, well, you had it then, you had a chance to look at it before you actually exchanged vows, you could have postponed and asked for an attorney to help you with this, And because my client decided not to do that because she wanted to go forward and she was in the mindset of getting married after being together for 8 years, she did not want to not do that. And so she took a quick look at it. They did make some changes to it. And
What
then it was entered
impact
into.
do those modifications have on the enforceability of the prenuptial agreement?
The way, I mean, one of the changes was pretty significant, and that actually impacts one of my other assignments of error. However, we're talking about a lay person looking at a legal document, and without the advice or assistance of an attorney, they're not going to understand the legal consequences of entering into this kind of an agreement.
The change that was made was to her benefit?
It was to her benefit. It was. The second part of this assignment of error, too, is whether there was a full disclosure of Mr. Moskowitz's wealth and interest in his business, et cetera. But that's another part of it. If she had had time to review and time to talk with an attorney, those kinds of matters could have been cleared up. Instead, again, she's just shown this document at the last minute. And again, taking it as a whole, we know that Mr. Moskowitz went to a family member to have this drafted almost a year before they got married. He could have at any point said, here you go, take a look at it. If you want to get an attorney, let's have that discussion. He never did that.
Well, didn't he testify that he asked her if she wanted an attorney, and then he reported back to his lawyer that she wasn't going to have an attorney?
He kind of said that. Really what he said was, I'm not really sure if she wants to get an attorney. So I don't think that there was that discussion, but I know that that is one of the arguments, that there was a discussion. My client, on the other hand, clearly said, we did not have that conversation. Because then why would she have reacted the way she did when he pointed to the envelope in the back seat? Again, if she were aware there was an agreement, there was some discussion about getting an attorney, why would she have waited until they were at the ceremony to
In
review
resolving this dispute of facts, I mean, it's clear that the parties told some different stories about what happened from their experience with regard to this prenup. I mean, the trial court had to pick one version or the other, and it picked Mr. Moskowitz's version. Why was that wrong? Why was the trial court required to pick your client's version?
Well, first of all, I think you have to look at the credibility of the testimony and the evidence actually presented. But as I said, I believe the trial court in its decision believed my client, that she had not seen it until that day, that there were no real discussions. What I saw the judge focusing on was, okay, well, now you saw it. You're an older, more experienced woman. You've been through a divorce before. You should have said, okay, we're not getting married, and then go ahead.
I want to go back to the uncertainty as to whether there was a discussion that was had. What was to the best of your recollection, what was the testimony of the husband with regard to that?
From what I can recall, he said, as far as the discussion about whether there was an attorney or not.
But whether there was a discussion. You said that it wasn't clear whether there was in fact a discussion, but it seemed as if you were saying, but it was interpreted to be that way.
So Mr. Moskowitz testified, when asked that question, testified that there was discussion about an attorney, but then it was furthered, and I think it may have been in the deposition transcript, and I'm sorry, I can't recall off the top of my head right now, where he basically said, I just told my attorney that I don't think she wants a lawyer. But saying that
So
is
I think
a lot different than saying, we had a discussion and she said, I don't want to get an
So I
attorney.
think what you're saying is that there may be a discrepancy, or you perceive to be a discrepancy between the deposition and the testimonial evidence at the hearing.
That is correct.
In essence, okay.
Yes.
Understood. Thank you.
And then didn't the trial court hang some weight on the fact that the wedding was not what most people would describe as a traditional wedding, that it was a justice of the peace ceremony in an office building, there weren't guests there wasn't family there, there really wasn't a reception afterwards, it wasn't this sort of affair that we think of as a wedding, and therefore that it could have been postponed?
Right, I think, and that is true, and I do think that the court made that finding. The issue is you have to look at it, I think, from the party's perspective, because it's not only a matter of what was the financial outlay, and there was some financial outlay. It wasn't certainly a 100-person wedding where you've got caterers and things, but there was a financial outlay. But it was not only that, but the embarrassment of not going through with it. Again, this was something, they had been engaged since 2005. They got married in 2008. They had been together for a total of 8 years by the time they got married. She literally sold her house the day of their ceremony. And all of these factors she was thinking of, and this was the man that she wanted to spend the rest of her life with. And so
So with the embarrassment factor, first of all, the trial court, I think, made a specific finding that that factor didn't apply, correct?
yes.
And also, I mean, I understand what you're saying as far as they've been together for so long, but what difference would another week make?
Well, I mean, I don't know that we can put ourselves in her position. She testified that it was shocking, it was confusing to her. This is something, it was very embarrassing for her not to go through with it, and that's why she made that choice. Whether or not any of us would have done that, I don't know the answer to that, but that is something that the trial court should have considered.
I mean, I think it did consider it, right? I mean, the fact that it made that finding shows that the court did consider that factor.
I think the court did not put a lot of weight on that because of the court's own position that, again, she was older, she was more mature, she had been through this before, she should have known better, basically, is the way I interpreted the judge's decision on that. The other part of the prenuptial agreement is the financial disclosure, and I just want to touch on that briefly, that there was, although there's no question that Mr. Moskowitz owned 15.5% of the business at the time he entered into the prenuptial agreement, there was no full disclosure that if what the partnership agreement happened, which is ultimately what happened a few years later, is that he would retain sole ownership of that business, which was not fully disclosed. So that's another part of whether the prenuptial agreement should be found valid and enforceable, and we're asking the court to consider that and to set it aside. I also want to get into the other assignments of error that I had, and one of them.
Counsel, you have about 10 seconds left.
Okay. I will address that in my 5 minutes. Thank you
Great.
very much.
Thank you.
Good morning, Your Honors.
Good morning.
So starting with this first issue that we just discussed, presented for review with the validity of this agreement. There is case law that says there is a presumption of coercion and overreaching if an agreement is presented a short time before the wedding and if the postponement of the wedding would cause significant hardship, embarrassment, or emotional stress. Mr. Moskowitz is not contesting that the agreement, the final draft of the agreement, was given to Ms. Mahoney on the way to the wedding. But he did testify that he believes that they discussed it before, that she helped him create the asset schedule that was attached to the back of the prenup, listing her assets and his. And that he had asked her if she wanted an attorney, and he testified, I think I asked her and she said no. He also wrote a note to his lawyer that was introduced into evidence back in 2008, like 2 days before the wedding when they were finalizing the prenup, that stated, I don't think Bridget wants an attorney. And he explained that that was because of a conversation that he had with her. So the court did make a specific finding that while the agreement was presented very last minute, it wasn't because of any intent on husband's part to deceive or trick wife. It was just done very last minute. And when I say it was done, I mean this wedding as a whole.
Yes, wasn't there evidence that the parties kind of threw the wedding together sort of on the fly a little bit? Because when they went to get the marriage license, they didn't have a date yet, they didn't have an officiant picked out, that sort of thing?
There was. So the marriage certificate was obtained on April 30th, and on it they listed that unknown was expected to perform the ceremony because there is testimony that they did not actually have a wedding date selected when they got the license. They were talking that it's time that we do this, but there was testimony, Mr. Moskowitz testified that it wasn't until the next day on May 1st, or maybe 2 days later if there was 31 days in April, that Ms. Mahoney said, let's get married this Friday. So it was very thrown together, and that same day, he then reached out to his attorney to say, hey, we need to update the asset schedules on this prenup, or I'm getting married. The wedding, as you mentioned, was not what one would describe as a traditional wedding. There was no family invited. It was just the two of them in a building downtown with a justice of the peace. And there was talk of some financial commitments made with this wedding, that just entailed booking a hotel room for an evening to stay downtown rather than going home. There was also evidence that, yes, Ms. Mahoney did sell her home that day, but she was the titled owner of a home she already owned with Mr. Moskowitz.
So she was not going to be out on the street. She had another place to live with him,
Correct.
married or not.
Correct.
Do we defer to the trial court's factual findings with regard to credibility? There's been an allegation that perhaps Mr. Moskowitz's testimony wasn't all that credible, although the trial court deemed it credible. What is our obligation on appeal with regard to that finding of credibility?
So I believe the court's obligation on appeal is that you do defer to the trial court's finding because it was in the best situation to observe the witness's demeanor and hear this evidence firsthand, which just doesn't quite come across in a transcript. So yes, I believe the obligation would be to defer to that finding. At the end of the day, there was conflicting evidence presented, but it was testimony. And the court, as you indicated, had to pick one or the other, and it found Mr. Moskowitz's testimony to be credible as to the events surrounding the execution of this prenup. And I will point out that the court did rely on the fact, I think a little bit, that wife was divorced twice before and should have known about some property rights from going through those processes. So she did have that knowledge. And at the end of the day, canceling this justice of the peace with no one even knowing that this was going on, and going another week or two to get an attorney and talk this through was something that could have very easily be done. And wife made the decision not to.
What impact does it have that the parties apparently had a conversation and agreed to cross out some of the provisions in the prenup to the benefit of wife?
Well, I believe that is just more evidence that wife read and understood this prenup and that she was not disadvantaged. She had the wherewithal to go through this, recognize a provision that was not favorable to her, and she testified that she requested that that be struck out, and he agreed.
And if I'm remembering right, they initialed beside crossing it out?
That is correct. Both parties did.
How would they have known to put their initials there? Did the agreement itself indicate that if they were going to make changes, they should have initialed them?
It did not. Both parties also initialed each page. There was no testimony about how they decided to do that, but that is what they did, and they did both initial those changes.
Does that suggest anything one way or the other?
I mean, to me, it suggests knowledge on Ms. Mahoney's part of the appropriate way to do this and just an understanding of this agreement, that she was entering into a legal contract and she signed it with formality, and when she made this change, they both initialed.
Can you address the property disclosures, the two exhibits that were attached to the prenup?
Yes, so there was some conflicting evidence about number of shares that were owned by husband at the time this was executed. The property disclosure lists that he had an interest in a business and lists the estimated value. And the prenup actually states that the parties are acknowledging that this is not necessarily completely accurate. It's a good faith estimate. It could be book value or just current market value depending on what asset it is. And there's case law out of this district that says general knowledge and understanding of assets is sufficient. It doesn't have to be valued down to the last penny in order for the court to find that there is full disclosure. So at the end of the day, whether Mr. Moskowitz had 10, 15, 20 shares, what this court should be worried about is, did he disclose that he had an interest, and did he disclose an approximate value along with that interest? So wife had that general knowledge, and he did do that. Wife testified that her financial disclosures were not accurate and argued that that should be part of the basis for setting this agreement aside.
Can we pause about husband's disclosure? So my understanding of the argument is that from wife's perspective, husband should have disclosed the percentage of these companies that he owned rather than saying he had an interest valued at X and Y, because the percentage of his ownership grew and changed over time, and that she wasn't able to understand or appreciate how much his stake in the company was worth without that percentage of ownership information. Did he have any obligation to disclose exactly what percent of the companies he owned?
No, Your Honor, because of that case law that says general knowledge is enough. And that argument is almost complaining that husband did not predict the future, because yes, the other shareholders retired pursuant to a shareholders agreement, and they sold their stock back to the company. It was held by the company as treasury stock. That impacted the percentages just because there was fewer outstanding shares. Mr. Moskowitz was then the only shareholder, but he still had the same shares. And there was no way of predicting, though, that that would occur during the marriage. Both parties, God forbid, could have passed away before these other people retired. They could have gotten divorced before these other people retired. So the fact that he did not give her a copy of a shareholders agreement explaining how this all might happen at some point during the marriage does not support a finding that there was not full disclosure.
I recall there was some evidence that she might have worked in a very limited way for these companies, especially early on in the relationship. Would her connection as an employee or independent contractor, I don't remember what it was, of these companies, would her work there have provided any information to her about who owned the companies or who else was in the shareholder situation with Mr. Moskowitz?
So it's possible. There was not evidence presented to that effect. And I will say that the testimony about her work was that occurred at a certain point during the marriage after this agreement had been signed.
Great, thank you.
But there was evidence that these parties had dated for 8 years before this agreement was executed. And my client testified, Ms. Mahoney did not disagree, that while they were dating, he was actively in the process of divorcing his first wife, and that she was his emotional support through that process, that she talked him through that divorce, and he relied on her for a shoulder to cry on and advice as to what to do. So that, I believe, is evidence that she also had knowledge of his finances, that she was so involved and supportive of him during a process that you're dealing with assets and the division and what's going to happen. On the topic of husband's disclosures, there's also a mention in the brief about a debt owed to husband's ex-wife that is not listed on the asset and disclosure schedule. And I do just want to point out that there is case law out of this district. I think the case is Azarova. It's listed in my brief, that talks about when a debt is inadvertently admitted off of an asset schedule, that is also not evidence that should be relied on to invalidate an agreement, because if anything, it means that an asset is overvalued then, and that the court's focus should be on disclosure of assets rather than were all the encumbrances accurately listed. Kind of going back to wife's disclosures a little bit, there was some testimony and evidence, and it's talked about in our briefs, that her disclosures may not be necessarily 100% accurate. I believe there's an account that's listed as an IRA that she said is an annuity, and a couple details like that.
Well, her house was on there both as an asset and a liability, but she had sold it that day. Why didn't they mark that out?
Well, I can't speculate as to that, and there was not evidence as to why they did not mark that out. But at the end of the day, the financially disadvantaged party maybe not accurately disclosing their assets and debts is not grounds to invalidate an entire agreement. And if we look at it that way, it would almost encourage a party to lie and hide assets and then later know that they can use it as a basis to just get out of the agreement.
So better to over-disclose, is that your position?
I mean, I think the case law certainly supports better to over-disclose and avoid a whole lot of litigation later, but the rule is general disclosure is sufficient. Regarding the differences in shares, so there's a lot of testimony about this. The evidence established that Mr. Moskowitz did have the same number of shares as at the time of the divorce that he did at the time of the marriage. And as I kind of touched on before, what occurred was the other shareholders retired and sold their shares back to the business. So while that changed the percentage of outstanding shares, Mr. Moskowitz did not personally purchase any additional shares. He did not personally pay for these other shares. The company paid the other shareholders pursuant to this agreement the value of their shares upon retirement pursuant to a formula that was set forth in the shareholders agreement. And the evidence established that that agreement was negotiated, signed, entered into by the shareholders long before her husband's relationship with wife ever began, and that he did not have control over the terms of that. He was a minority shareholder at that point. There was some documentation that was presented that wife relied heavily on, which did list a different number of outstanding shares on different dates. But the accountant that prepared those documents testified that that was an error on his part, that he reviewed other documents that he knew to be accurate that confirmed that husband never personally acquired any additional shares in this business at any point during the marriage. And in looking at the antenuptial agreement and considering shares in this increase, I will point out there is language that states that Mr. Moskowitz's interest in these companies is his separate property, and it includes any appreciation of separate property, and it does not differentiate between active versus passive appreciation. So in our view, this change in value due to the shareholder's retirement, yes, it increased the value of his shares a little bit, but it was really just appreciation. The ultimate assets that he owned stayed the same. The value just changed depending on how the company was doing, and his control over everything certainly changed when everybody retired. But that was certainly not...
Would the potential for those fluctuations have been evident from Exhibit A?
Not necessarily from Exhibit A, but certainly the expectation would be that all of these assets could fluctuate in any prenuptial agreement, that everyone understands that an investment account is not necessarily going to sit there in stone, set the exact same number, just as it would with real estate or with any other asset that can fluctuate up and down. So I would say that again goes to just general knowledge and understanding, which is the standard here, that things can change as time passes. Does the court have any other questions for me? Because I think I'm about out of time here.
Thank you.
Thank you.
Putting aside the prenuptial agreement, if this court upholds the trial court's finding, I still think that we have significant arguments regarding the assets and liabilities of the marriage. Specifically, were the UBS accounts, where money, although listed in Mr. Moskowitz's name and or the name of his new business, it was funded largely with the sale of his business. So the big question, I think it came up a little bit with what was just mentioned, is that 15.5% is what he owned at the time of the marriage. By the time he sold the businesses, he had 100% ownership of these businesses. So his percentage increased 84.5%. There was language in the prenuptial agreement that was actually crossed out. That was part of what the crossouts were. Language that said any property acquired subsequent to marriage but maintained by that party is no longer a separate asset. Where we see that largely in prenuptial agreements, that language did not exist in their agreement. So anything acquired by the parties, regardless of whose name, would be considered a marital asset. And so our argument is this is not appreciation. This is not a matter of market fluctuation, that is 15.5% went from $100 to $1,000. He acquired an entire company, which he then sold.
How did he acquire it? Did he purchase shares somehow? Was there a transaction? What does the record reflect?
So the record reflects that there was a purchase agreement where he had to pay out the other shareholders, he being the company. I mean, yes, we're distinguishing, but he was the sole member of this company, the sole shareholder. And so he was paying out the other two that had retired from the company.
From the corporation.
Correct. And so as a result, it was not appreciation, because when we think of appreciation, we're talking about market fluctuations.
Is your argument that he is essentially an alter ego of the corporation at that point, and so the corporate assets should be treated as his?
Well, in the sense of he is the sole owner of it, he had sole control over it, and he benefited once he sold that company because he retained, other than paying out what needed to be paid out, he retained all of those funds. So yes, he was I don't want to say I'm not piercing the corporate veil. What I'm saying is he was the only member of that corporation, and that he acquired that during the term of the marriage, which then makes that marital. And if that is the
What
way.
what you're saying is the 15% ownership grew to 100%, and in essence, it was akin to having then ownership purchase of the 85.
That's exactly right.
Okay.
Because I heard the accountant testify, well, his shares didn't actually change. There were some documentation to show his shares did increase. But even the accountant said, well, I looked at other documents, but I can't tell you because of confidentiality. So that information could not be
And
shared.
I'm going to put it a
or
little
verified.
differently, which I think what you're saying is it is in essence as if he went out and purchased the 85 because as the corporation had the responsibility to pay these out when the individuals sold them back, right?
That's correct.
And so that, even though he wasn't doing it personally, but it had the same net effect.
Correct.
Okay.
And if that's the case, then the assumption made by Ms. Ashbrook in what the funds were and whether it was separate or not separate in all the UBS accounts then goes out the window. Because she said, I'm basing my, percentage of separate property on the assumption that any money that came in from the sale of this business is Mr. Moskowitz's.
I don't recall this from the record. When the two cousins retired, did they retire simultaneously?
It was very close in time. If I'm recalling correctly, one was maybe early 2009, the second one was later in 2009. I think it was very close in time, or maybe 2010, but it was very close in
Was the
time.
purchase agreement for buying the buyback of their shares, was that one purchase agreement or two separate ones?
I think it may have been two, but I don't want you to quote me on that because I can't remember specifically.
And that information would be in the accountant's testimony?
In the accountant's testimony and also in the documents, the exhibits that were at trial.
From the accountant?
Right.
Okay.
But even assuming that this court does not find that 84.5% of the proceeds were marital, then Mr. Moskowitz argues, well, I use marital funds to pay all my liabilities as a result of these businesses. He cannot have it both ways. So if he wants to say this is my separate property, then any money he paid for tax liability based upon the company income that he received should be his separate liability. And in fact, the prenuptial agreement specifically says that, with no exception.
And counsel, you're out of time.
Thank you. Thank you very much, Your Honors.
Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision. Next, we have two consolidated cases, C-250096 and C-250097, Bates and Judkins versus Durrani.
Colleagues, I will reserve 4 minutes for rebuttal.
All right. Welcome back to both of you, or all of you. Seems that we're doing this almost every day. We appreciate the frequency with which you are coming to argue. It's very helpful. Thank you.
It is always wonderful to see you, Judge.
Thank you. Same to you.
May it please the court, Philip Williamson on behalf of appellants Dr. Durrani and Cast. I think it's fair to say over the last several weeks, as we have seen each other a lot, the court and the parties are struggling with what we do with the consolidation decisions, really decision that was made below. The court has wrestled with how do we handle our prior precedents. I think the question of what do we do with Jones has come up pretty frequently. The question of like, what is a common question? We've talked about prejudice, and so I'd like to address a few of those, but if the court will indulge me, I'd start with a procedural recommendation. And that is, take one of these cases en banc and answer at least that opening question. What is the standard for a common question of law or fact under Rule 42? There are a couple of reasons, I think, to do that. The first is that all 6 judges on this court have, at this point, heard one of these cases and asked a series of questions about how to handle consolidation. We anticipate some of those questions will be asked in decisions in the next few weeks. That's not me rushing you, that is merely me sort of looking at the prior timelines. But what you have is a little bit of a lag time between the briefs that we're writing, trying to sort of read the tea leaves of either the decisions that you're writing or what we're hearing in argument. I'm writing briefs now based on arguments that I've had over the last couple of weeks. And then they sort of get mooted out by decisions you make in the interim. And so I think taking an en banc, maybe pausing the other cases, and then sort of giving us a standard against which we're drafting the rest of the briefs might, among other things, make us more helpful to you. And I think it's a question the court's going to have to harmonize in what I assume are the forthcoming opinions in the next few weeks or next few months. We submit you may as well all sit together and do the harmonizing all at once. It also, I think, answers the question, well, what do we do with Jones? What do we do with Courtney? What do we do with Boggs? If you're sitting on banc, you sort of don't have to worry about that, or at least don't have to view yourselves as bound by what happened there. Now, this happens to be a case where I think we've set out to distinguish nearly all of those decisions. But again, perhaps sitting on banc will allow you to answer the question and just get the law right without having to deal with prior past panel opinions or being informed by prior panel opinions.
So have you made any motions for any cases to be heard en banc?
Yes, Your Honor. In Courtney, we asked the court to take the consolidation question en banc, specifically to harmonize the decision you issued in Courtney with the sort of the standards in the mandamus action, which we thought were dissimilar there. And I think as we kind of detail in our briefs, in the decision since Courtney, that gap between the mandamus action in your last opinion and even between Jones in your last opinion, I think has only continued to widen. Though if memory serves, the court actually declined en banc rehearing in Courtney. Happy to make a motion here if that is what the court needs.
Mr. Williamson, I appreciate your procedural presentation. I have a specific question on the law. It piggybacks off a question that I asked yesterday.
Yes, Your Honor.
Does the legal standard for common question of law require a common question or a common answer? So would it destroy commonality if the answer to the question were different across the plaintiff's cases?
Yes, Your Honor. I think 2 things to say about that. First is that a common question of law is never really going to be a reason for consolidating cases for trial, because a jury is not supposed to be answering a question of law anyway.
Well, then why is it in Rule 42?
Because Rule 42 is not just about consolidation for trial. It is, if there's a common question of law or fact, you can consolidate for trial, for hearings, and I think typically if you had a common question of law to answer, you might consolidate for a hearing in front of the law.
Constitutionality of a statute or something.
Exactly right, Your Honor.
Right.
Now, as to your specific question, I think it's both. I think the U.S. Supreme Court sort of explained it best in its Tyson and Walmart decisions. You're looking for a common question that's going to generate a common answer that's going to drive towards the end of the litigation. That's why legal questions that are just the elements of the cause of action don't work. Because you're not, it's the same question. It is not a common question. It's not a question shared between the cases that are being consolidated. And you are, at the end of the day, looking for a common question that's going to get a single answer for all of the parties all at once out of a single presentation. You're not going to get that when, like, your legal question is, was there malpractice here?
And then another question for you. So my understanding of this case is that it originated with a class action filed in another county, and that the class action was determined, or that the case was not determined to meet the elements of a class action. Because that action occurred in another county and that record has never been in front of us, I don't know why. I don't know why the court determined that it was not appropriate for a class action, but I can surmise that commonality under the class action standards might have been a problem. Was it a problem, first of all? And then secondly, if it was, how does that analysis transpose to Rule 42 now?
The answer to your first question is I'm not entirely sure. Many of these cases have gone through a lot of different procedural wranglings. My best recollection of the class action element of this is when we attempted to remove the original like sort of 400 plaintiff group trial proposal to federal court, and under CAFA as a mass action, and the court essentially decided it didn't want to deal with the cases, and so the Sixth Circuit just didn't answer the question, and so the motion to have it removed was just denied by winding out the clock. But we do propose that the standard, that the answer to what is a common question of law or fact is going to be the same in Rules 20, 23, and 42, because it's the same turn of phrase in all three rules. That's part of the reason why we've relied on Rule 23 cases in our recent arguments, is that that's actually the best sort of guidance any court has given on what that phrase means.
All
But
right,
you are
so
looking
if
for the
that's
same
the
commonality.
case, if that's the case, if common question of law means the same thing in Rule 23 that it means in Rule 42, then it has to mean common answer, right? Because you can't certify a class if the answer is different across plaintiffs.
That's exactly right, Your Honor. It is only, the way we would phrase it is that what you're looking for in a common question is a question that's going to generate a common answer across all the cases. But you're exactly right. That's what you're looking for here.
So then what happens with the fact that sometimes in these cases, when they're consolidated, we see jury verdicts that are 8-0, all the claims against Jurani, and then sometimes we see verdicts that are 6-2 on one plaintiff, only on the negligence claim, 7-1 for the plaintiff on another set of claims for more claims, like that. Sometimes we see variation in jury verdicts that would suggest that the answer to the legal claims is not the same.
That's exactly right, Your Honor. If it is possible for the outcome of all three cases to vary as wildly as you are seeing in some of these actions, it's a good indication you don't have a common question of law or fact. I think there's another.
It depends on how you define common answer. So what is your definition of common answer?
You're right. It is where the answer to a single contention is going to resolve that contention for all of the parties in one stroke. So, again, like the question, did Dr. Durrani perform an
How do you
unnecessary?
define contention then?
It is, Your Honor, almost any sort of discrete point in the case where the same evidence is going to prove the same point for all of the parties at one time. It is not as simple as, the question, did Dr. Durrani commit malpractice? Yes, all of the parties are going to ask that. In the same way that, in Walmart, you might have asked the employment discrimination question, do all of us work for Walmart? What you're looking for is, I think that question is incomplete.
So what if it was whether it was Durrani's methodology in convincing patients to undertake surgery and the necessity of surgery? What if it was that was the commonality?
Well, first, it's got to be a question. But even there, you're still having to answer individually for each plaintiff. Did this plaintiff need surgery?
Correct, and thus you're going to have different outcomes. In some patients, it will be yes, in some patients, it will be no, because this is going down to the fraud claim, right? So,
Fraud claims are probably the least suited for consolidation, because reliance is going to be your key question in every fraud case. The state, it's not just like, did this person say the same thing to 2 or 3 people? It's got to be materially false, which can only be answered on an individual basis. A phrase may be, you need surgery, might be true as to one plaintiff and false as to another. And you can't prove that with anything resembling common evidence. You're also going to have a reliance question. Even if it turns
What's
out it's
interesting
false as
to me
evidence.
is I always think about criminal cases. So in criminal cases, there's joinder of defendants all the time.
Yes, Your Honor.
All the time, right? And so whether one defendant is criminally culpable is an individualized inquiry, even though there might be shared facts, and the same with the other. And the trier of fact can come out with different determinations, one guilty, one not guilty. Happens all the time. So why should a civil litigant have more rights than a criminal defendant?
Well, a couple of things, Your Honor. I see that I'm out of time, but I want to take a little time to unpack this question.
I'm going to
I think it's
give you that
important.
time. Go for it.
So part of it is that I think that the scenario you've described is actually flipped what you have here, right? You join multiple defendants when they're accused of participating in the same criminal scheme. You would not, I think, I cannot imagine any panel of this court would sign off on two criminal defendants accused of bank robbery who have nothing to do with each other, who are both put in front of the jury simply because, have you been accused of bank robbery? Have you been accused of bank robbery?
Well,
You wouldn't do that, right?
The scheme is what ties them together. So
Right.
it seems to me that in the Durrani cases, a scheme could be defined there. But I will also give you another scenario that you don't need to respond to because you are out of time. All the time, we see joinder of the same defendant for two different criminal behaviors.
So you see that, Your Honor, but it is, again, you're looking for an actual connection between those two criminal behaviors. You're looking for a
And
common
that brings
transaction.
us to the commonality here.
Right. You're looking for a single transaction, and you will see this in a lot of your sort of joinder of offenses cases. And in fact, it was the State v. Scheim case where you had sort of three discrete criminal sexual imposition cases involving three discrete victims against a single defendant. And in that case, the Ohio Supreme Court said these should have been severed because the evidence as to each particular victim doesn't actually inform you as to whether the defendant was guilty to the others. But it did have the effect of allowing the jury to think, well, he inappropriately touched this person, so he probably, in fact, in that case, it was, how do we read what could have been innocent or criminal behavior? Well,
It's okay.
because he's
You
been
don't have-
accused
you don't have-
once.
You don't have to continue to answer that. Thank you.
Your Honors.
Thank you.
Maybe I can help the court on the class action since I do know the facts. First of all, it was in federal court under Federal Rule 23. And the case was certified. And then it was later decertified.
But was that by the Sixth Circuit
No,
or by the federal
by the
judge?
same judge, Judge Black, who, through a series of discussions and negotiations between the parties, came to the conclusion that they didn't want to proceed as a class action, let's proceed on a more individualized basis. And it was
So it was
decertified.
by agreement to
I
decertify?
don't, that part, I was trying to find the entry, but it was not by a decision that then went up to the Sixth Circuit. And then what happened is the federal, well, it also, only some cases stayed in federal court. The one thing he was right about was that they attempted to remove it all into federal court. That didn't stick. That could have been one of the affecting factors.
So
But
are
it
you
was-
saying that the record does not have a clear determination that there was not commonality?
Yes, there is no clear determination
That there was
on
not
the issue of
But
commonality.
it sounds like there was a determination that there was commonality at some
Initially.
juncture. Okay.
But when you talk about a class action rule, it only has to have one issue that's common, at least one issue. So this idea of common answers, common questions, plural, doesn't necessarily apply. So the commonality
And that's one thing I
test-
think that's been left out of the conversation, that it is plural before us. It's not singular.
So The other issue, which you and I debated yesterday, was the meaning of common. And when you have things in common, I looked at all the different dictionaries available, Webster's, dictionary.com, and alternate meanings for common is similar. And I actually took a screenshot.
That's okay.
And not to try to be argumentative about it, but I felt similar was there's a cornucopia of meaning of common. Most don't apply to our situation at all. In the hierarchy, most of the ones that are 1, 2, and 3 aren't even applicable.
So if the class was certified in federal court, what was the common question that the trial court found to justify Rule 23 certification?
I don't recall, because it was
Okay.
2014 to 16 that this
Fair.
was occurring. And
But there would be an order.
there's a record that would answer these questions. It would show the certification, the decertification, the sending cases back to common pleas, keeping others there.
And presumably that was litigated. I mean, numerosity would clearly not have been a problem. I'm just hypothesizing, I truly don't know, but I would think commonality would be the battleground in that case.
Well, I wasn't.
Am I right?
I wasn't the litigator at the time. I came into this in late 2017, but I generally know the history of the federal court because we have procedural and legal issues that are now in the Sixth Circuit that involve the progression of how everybody ended up where they were, and that is why I know for certain it was certified and decertified, and it was Judge Black that did that, and it was between 14 and 16. But I can't give you down to the nub because I wasn't the attorney litigating
Okay.
it at the time.
Okay.
But there is a record.
All right, and certainly Judge Black would have had to have found that there was some common question
Yeah,
in
that you
order
would
to
have had
have
to find each
certified.
of the elements to put on an entry that ordered certification. So that all fell apart for whatever reason. And when you then look at what Judge Black did, and then you go over to Judge Barrett, who actually tried the cases, he had no issue with consolidating the cases because we were doing 6, we were doing 3, we've got more coming up that are consolidated. And so, at least in terms of the federal court, we haven't gone through the same level of machinations about consolidation, although they're objecting, and we'll ultimately see what the Sixth Circuit has to say if and when that issue gets there. It's not been before them as of yet. So
We've talked quite a bit about a common question of law, but Rule 42 also allows consolidation for common questions of fact. How is a common question of fact different from a common question of law?
well, it's the same as the jury instruction. The law is existing, and the judge is going to instruct the jury on that. They're the judges of the facts, which is what actually factually occurred, not what legally occurred.
So
So
I think that, maybe I'm not understanding you properly, but it sounds like you're saying that if the jury instructions would be the same in case A versus case W, they can be joint. Is that what you're saying?
Well, I am, and if you remember yesterday.
I do
Sorry,
remember
was trying-
yesterday.
Right. I think we talked about that just because the law is the same, you can't grab 2 different attorneys off the street that both have medical malpractice cases with different people and ever see those guys getting together and say, with the same doctor, and let's try to consolidate this. So it is more peculiar to the Dr. Durrani situation, and you'll be facing it in another case that I have that has over 200 litigants that I represent and another 140 that about 6 or 7 other lawyers represent, and how that's going to proceed. But I do want to bring up something that hasn't been considered before. And I think that it's important. You may not think so, but when I was getting ready this morning, and I knew we had all those arguments, yesterday I said to myself, what really is the differentiating factor here? And then I started to think about the fact that the Supreme Court consolidated all the cases under one judge, and that has caused us to proceed through 127 jury trials with another 40 years to go if you divide it up and say one at a time. And so where does the right to a civil jury trial come from? And does moving forward on an individual basis deny these people their constitutional right to a civil jury trial and a timely civil jury trial? Not a jury trial that would take another 10 years when they've already been in the case, 20 years.
Have you filed motions to that effect, asserting a constitutional argument?
I just thought of it this morning. I was trying to think, based upon the questions you were asking yesterday, how do you balance Rule 42 if you're leaning towards the appellant with the appellee's own rights to actually get a timely jury trial? And who ends up being more important, the Ohio and U.S. Constitution or Rule 42? And how do you balance
Well, surely
that?
the rule is there as a docket management, mechanism to help cases move forward efficiently. Surely that's one of the purposes of the rule, right?
And that brings us back to the fact that that is what has happened here, that it's just as much about how do we get these people to trial in an efficient way when you have common law firms, common judge, common defendant, common issues, common surgeries. And what brings it into focus today, which I think is important for all of you to be aware of, because we talked about it yesterday, is when I was saying, let's throw the lumbar vertebrae on the floor and let's see who can decide which is L3 and L4 versus L5 and S1. Well, in today's case, you have Judkins having a T-lift at L4-5, and you have Faulkner having a T-lift at L3-4. So this starts to come down to the fact that you got to identify a level, but it's really no different than if I'm going to operate on a right arm or a left arm. I've got to say right arm. But if we're consolidating cases, if it's the exact same surgery, under the exact same circumstances, under the exact same representations, done the exact same way, or similar procedures that are allowed, does it really matter if it's left arm or right arm?
And so are you saying that that's the common question of fact, the surgery that was performed?
It's a lumbar fusion surgery. And whether it's a T-lift, an A-lift, a D-lift, those are a process that's not even being contested in these cases.
And that would distinguish this set of cases from something like we were talking about yesterday, my hypothetical with an attorney malpractice case, where an attorney is, misrepresenting something to one client and then misrepresenting something to a totally different client in different kinds of cases where there's nothing the same, even though the legal claim is the same.
Yep.
There's no facts in common. That would distinguish this situation from something like that.
And the facts are, Ben and I were talking this morning on our way up here. When you remove an appendix, it's just an appendectomy. You're not talking about, is it a left side or right side? Is it up or down? Is the person a male or a female? Are they African American or Caucasian? None of that matters. That's not what's going on in a medical process and procedure. A T-lift is the same whether you're a male or a female.
Counsel, is it critical for the resolution of these cases that the plaintiffs had a T-lift versus having a fusion versus having one of the ectomies, which I don't know how to pronounce?
We have gotten dragged into this minutia by the appellants. I don't blame them. They're trying to distinguish the minutia. By getting into the minutia, they go, aha, T-lift, aha, D-lift.
It goes back to the definition of common, whether it's identical or something else.
Right. And how deep are you going to go? Is a spine surgery a spine surgery? Is a fusion surgery on a spine a fusion surgery on a spine, whether it happens in the lumbar or the thoracic? And then you can start to get into more minute details because you have people and you can't put 400 people in the same trial. So you come up with differentiations by using some of the minutia to narrow it down. Okay, we'll put these 3 together, we'll put these 2, we'll put these 3. But it's really for purposes of staging, not really because we're saying, oh no, a thoracic fusion is different than a lumbar fusion. They have to be tried only with thoracic surgeries. No, we did it to simplify so that, okay, we're just going to have lumbar if we can do that. And what's been, I think, not properly represented to the court is that both sides give the judge their list and the reasons for consolidation. And he doesn't pick our list every time. There's a discussion, and then he comes out with an order. The only thing he gives me preference on is who I get to try first, because I'm the plaintiff, and I shouldn't be forced to try number 7 if my preference is to start with number 27. That's the only thing I get to pick. Otherwise, we submit the list, and this representation that the judge isn't going through an analysis, yes, he is. He's looking at the lists, and it's in the supplementation of the record that they filed. So we've been dragged into, wait a second, did he put an I? Did he put a dot over that I versus he didn't put a dot over this I? And you can look at a broader picture. Like I told you, there is evidence in these cases, specifically in these cases, that are in every other case, in the list of impressions. Spondylolisthesis. They never have spondylolisthesis when they get to surgery. That's a way of getting paid by the insurance company. Spondylolisthesis is a slippage of bone that justifies stabilization. So if he can get away with a spondylolisthesis, he can take it from a simple decompression to where the decompression, it's still unstable and he has to fuse for the stability. But the whole process is decompressing the nerve and getting that weight, whether it's coming from a disc or whether it's coming from the bones, off the nerve. That's what it's all about. And they have to do, in essence, every fusion involves a foraminotomy, because when you take out the disc and you put the spacer in, it makes the foramen larger, which is the whole purpose of a foraminotomy. They all included discectomy. So when you get into the minutia of how the surgery is performed and why, the basis and the elements of the surgery have a significant amount of commonality in a layman or physician or medical sense. But we've been dragged into this by all these appellant arguments that commonality has to be so specific that they have to have the same medical history, even though Dr. Durrani never looks at it, and so forth and so on. I see I'm out of time.
Thank you.
But hopefully I've given at least somewhat thought about how else this could be looked at. Thank you.
Thank you.
It's a good thing, so I don't want to steal that from you.
Well, you would end up with blue all over your hands.
Fair amount of ground to cover, Your Honor. I'm going to start at the end. So, spondylolisthesis is in every one of these cases. You would expect to see something like that in the statement of facts in Appley's brief. It's not there. Like much of the argument, these things are not there. And here's why it matters. We are wrestling with this common question issue on the fly. The trial court did not do anything to help you out. The analysis is
So
not.
what's a common question of fact as opposed to a common question of law? What does the common question of fact standard mean?
It means that you have a factual contention that can be resolved with common evidence or proved with common evidence for all of the parties all at once. The prototypical example of this would be something like a toxic tort spill. You only have to answer the question, did the company, spill this chemical into the water supply one time for
So it's a
everybody in town.
question of material fact?
I think when you're deciding whether you're going to consolidate, absolutely. It's important to note in Rule 42, consolidation isn't mandatory. You don't find a common question and say, well, we've got one, now we're going to consolidate. It's still permissive, and you would absolutely ask, is this actually the kind of common question that justifies the prejudice that we create by putting these parties together?
Is the nature of these surgeries, I think we've honed in on the surgeries themselves, and our precedent has established that one basis for commonality could be that the 2 or 3 plaintiffs who are consolidated underwent the same surgery. Is this type of surgery and the facts about how it's conducted, is that a material question of fact in these cases?
I would submit no, when the principal question is not what surgery did you have, it's was your surgery medically indicated? In the case of the fraudulent misrepresentation
But does
claim.
it play into damages? So like, are some of these surgeries maybe less invasive than others? Like, does it matter as to what kind of surgery the plaintiffs suffered through, assuming that the plaintiffs are successful in their claim that they didn't need it?
Generally, no. There are 1 or 2 cases, I think, Walls and White, that this court decided, where like one of the issues was a particular plaintiff wanted a less rather than more invasive surgical option. But generally speaking, you don't see that turn up in the damages. The past medical damages are basically, what did you pay for surgery? We'll give you a refund on that. There's some fighting over like what the right number is, but for these purposes, no, it's not. It's often not typically material. Look, the material question is, was this surgery medically indicated for this plaintiff? And there is no question, there is no point of proof, there's no jury interrogatory that answers that question one time for all of your plaintiffs. I would point the court to even Judge Reese's solution for consolidating the cases, which is to give the jury 3 separate notebooks. If the cases can be wholly contained in separate notebooks, doesn't that suggest there's no common question among these cases? If you think the jury can sort of hermetically seal each of these cases, there's nothing common, nothing shared between them.
Wouldn't that be the same in my example of 2 defendants? Even though it's the same crime, each one would have to be determined whether they have criminal culpability?
If they are committing the same crime, like, for example, when you've
Well,
got
if the crime is
co-conspirators,
connecting, yeah, they were co-conspirators or they were whatever it is, but.
you would absolutely try co-conspirators together. I think
But you have to evaluate them separately. You're not going
So
to
you're-
evaluate it all together. You're going to evaluate it separately, ultimately. The culpability is going to be determined separately.
Sort of, with a.
Because I'm looking at language from Jones, plaintiff, whether the plaintiffs raised the same claims against the same defendants, asserting the same theory of medical malpractice and fraud.
Your Honor, I mean, I think part of our argument is,
You don't like that, I know.
Your Honor, more sophisticated than that. It's that there's no question identified in that language. That I think is our concern, and what we are hoping to sort of steer the court towards is, where's the question? Where's the question mark? And where, again, what's the contention that gets resolved one time in one fell swoop with one presentation of evidence for all these parties?
Counsel,
Your Honor, I
you're
see I'm out of time. Can I give you the case citation for the Scheim case so you can
Yes,
find
please.
it? It is 65 Ohio State 3rd, 51.
Thank you.
And it's SCHAIM. Thank you, Your Honors.
Thank you both for arguing again this morning. We do appreciate your time. We will take the matter under submission and issue a timely decision. Enjoy the rest of your day. Yes, thank you. We know you will be back. Our final case this morning is C-25-0346, Clark versus Anjuli. I believe I got that right.
You did get it right. Your Honor, I neglected to introduce to the court a new lawyer in our office, Sadie Sam. she'll be up here arguing next time, maybe.
Wonderful, welcome.
Good morning, Your Honors.
Good morning. Would you like to reserve time for rebuttal?
I would, 3 minutes, please.
All right.
Your Honors, we're here today on 2 issues presented. The first has to do with the judge, although writing wonderful orders, we believe has made an error in determining which facts she believes and which facts she doesn't believe based on various evidence with regard.
You're basically saying the judge weighed the facts in its determination.
That's exactly what I'm
Okay.
saying. That
Now,
she,
we get to know vote, right?
Yes, you get to know
Okay.
both. That's exactly right. And thank you for bringing that up. This was a summary judgment that was granted in favor of defendants. So, I mean, even if you look at the briefs that were submitted to the trial court, they're very fact-specific. They're evidence-specific. We've got one person testifying, for example, that these people we know, so I'll take a step back, that these people we know were bouncers who assaulted the plaintiff. We know they're bouncers because that's who the bartender signaled the plaintiff should talk to.
Who testified to that? I mean, that was the plaintiff's testimony, right?
That's correct. That's the plaintiff's testimony. And then, by the same token, we have the other side saying, "Oh, we know they're not bouncers because they didn't wear black shirts." And then we
Well,
say,
that's not all. I mean, that's not all. Like, they testified that they don't know them, they don't work there. I mean, the bartender testified that they were there as his friends.
the bartender, I believe, testified that the manager actually introduced him to at least one of the bouncers, who the record knows only his forehead, approximately a year before this event occurred.
Well, is that what he said? I thought that he said that he knew Caleb and Forehead and that he suggested that one or the other of them talk to the manager about getting a job there, but he never said that that conversation actually happened.
He did make the suggestion that they speak to the manager, but I believe his testimony is that the manager actually introduced him to Forehead, and that was the nickname the manager referred to him as.
Well, he said that I thought his testimony was kind of ambiguous in that regard. He said that it could have been Dante or it could have been Marty, the owner, and that he wasn't sure.
Yes, yes, that is correct. But either one of them have the ability to hire, because Dante is the manager and then his father, Martin, is the owner, and either one of them have the option to hire the bouncers. And if we look at who hires the bouncers and exactly how they're hired, it appears that based on all of the testimony, that it's almost a shoot it from the hip sort of, hey, we know you, you're someone who we trust, I guess, and would you be a bouncer this evening? We'll pay you at the end of the night. I mean, and they're
And I think the record is clear that the bouncers were not paid under payroll.
that's correct. There's
So
no.
it's very interesting because a lot of the questions use the word employee. An employee can be a term of art depending on how it's used,
Yes.
okay? So I found that very interesting because when we're talking about vicarious liability, it's about control, regardless of the title.
Yes, it's absolutely about control, and as long as the actions are within the scope of what they were quote unquote hired to do, what these bouncers were hired to do.
How would we know that? Are there any facts in this record? I understand you're arguing that there's a dispute of material fact as to whether they were employed, and we'll just say that that means like paid to do something by
Okay,
the
yes.
bar. And I understand your argument in that regard, that you're saying that the facts could go either way and it should really be a jury question.
Yes.
But if we agree with you, are there any facts in this record as to what they were paid to do? and what they would have been directed to do by the bar so that so that the jury could flesh out the vicarious liability claim?
So yes, there is evidence, several-fold. One of them is that they're gentlemen who are sitting in the middle of this bar. Actually, one was sitting and one was standing. We can see from the video, in the middle of the bar.
Well, I've seen the video. I mean, other than the video, like, I don't know that the video shows anything about what they were actually paid to do. So who would have directed them? What would the scope of their job have been? Don't we need to know that information in order to resolve the vicarious liability claim?
So there are several cases where essentially the court says, well, for example, if a bouncer commits assault, we know that's within their scope. That's a sort of quintessential epitome of someone acting within their scope, to say, okay, well, this person is a bouncer, and
So we should
being a
just
little
read it
overly-
into the job title?
Certainly, they don't have authority to commit assault, but yes, that's within the scope of their employment as a bouncer. And as I said, there were.
Because on this record, like, I was reading about how they were talking about having a bouncer at the front door to let people in.
Yes.
And presumably that person had some instructions about who they were supposed to let in and at what time and whatnot.
Yes.
I didn't see any information about what the people were really supposed to be doing who were bouncers inside. So assuming that was their job and that's what they were supposed to be doing, how do we know what was within or outside the scope of that?
In part, as you said, the job title bouncer, and also to look at what they clearly were not doing. They clearly were not taking money. They clearly were not checking identifications. So that wouldn't be within their authority, or excuse me, within the scope of their.
How would we know that? Like, how would a jury, assuming we agree with you and there's a dispute here, and
Sure.
we send this back and we say, jury, decide this case, how are they going to know what the scope of this interior bouncer job is to know whether these two folks were acting inside the scope of the job or outside the scope of the job when they engaged in the encounter?
So for one, when the bartender indicated, and my client testified that the bartender indicated that he should take up his issue with these two people in the center of the bar, I think it's clear from that part of the scope of their employment is to resolve these disagreements between, for example, the bartender and a patron. Again, no bouncer has within their scope actually to assault a patron, but their scope is to resolve issues, to have this pseudo-security job, and this overzealous behavior that's an assault is within that scope.
And the source of that information is from Mr. Clark.
That's
only.
correct. That's correct.
Because as I read the other witnesses, they were saying that the manager is the person who would come and intervene with unruly customers.
Yes, they said that they were trained to get the manager if there was an unruly customer or situation they couldn't handle. But yes, Mr. Clark is the person who testified that the bartender actually signaled him to take the disagreement with the receipt up with these two people, these two bouncers.
I do find a very interesting fact that the trial court puts in their entry, which is substantiated by the video, and I'm going to paraphrase it, but it was that the manager grabbed Clark, handed him over to Caleb.
Yes.
For Caleb to remove him from the bar, basically. And that's a finding of fact or a determinate, or I don't know if it's a finding of fact as we're summary judgment, but that's a reflection that the trial court makes on reviewing the video of characterizing what's in the video. And the video is evidence, right?
Yes, the video is evidence.
So would you say that that is consistent with what would be expected for a manager's behavior to be when they're engaging with a bouncer?
Specifically handing the patron back.
In order for the person to get them out of the bar?
Yes, that's certainly consistent with someone being a bouncer, and that's also consistent with this notion that the pseudo-security job is within the scope of their employment. I mean, the manager is behaving in such a way to say, here, this person is someone who you need to deal with.
And the other thing that I found interesting is the testimony about these red stools, that the red stools were where the bouncers would be located. And the video shows these two individuals, one sitting on the red stool that's facing towards the bar, one standing by the red stool that's facing towards the door.
Yes.
Certainly there's different reasons why that is, but in taking the light most favorable to the non-moving party, what would that mean?
So again, it would be indicative that this person was quote-unquote hired, was being paid to be a bartender, to be a bouncer. They've, as you said, they've got this red stool. If you take a look at the video, it's not apparent that there are other red stools throughout the bar. For example, the patrons sitting at the bar, there's certainly no view that demonstrates that those are red stools. So I think that's consistent with them being bouncers, with them being someone who has, within the scope of their employment, some responsibility for this, as I'm describing it, pseudo-security role.
Dante in the video, the manager, he comes and intervenes, and one of the first things he does is he grabs, I can't remember if it's Caleb or Forehead, but he grabs Caleb first before he grabs the patron. What do we make of that?
Caleb is the one who was actually perpetuating the assault at that time. It makes, it really doesn't make sense to grab the person who's laying on the floor being kicked and hit, and the person who's suffered all of this injury. It makes better sense to address the person who's actually committing the assault, to say, okay, if we're gonna pull two people apart who are fighting, you pull the aggressor off
So
first.
doesn't that defeat then your claim that the bar owner, the bar manager did nothing to stop this fight? On the premises liability claim?
So our argument on the premises liability claim is that the bartender, not the manager, did nothing. The bartender is the one who was there in the first instance, who was there for the first, 30 or 35 seconds of the video, who said, take it outside, take it outside. Didn't say stop, didn't say I'm going to call the police, didn't say, hey, you call the police, didn't take any action to rescue. And our second argument on that issue is that the manager, in handing my client, physically picking him up by the shirt and handing him back to Caleb, he's actually even assisting to perpetuate this assault, because he's handing my client back to the person who has been kicking him while he's on the ground and hitting him, to drag him the rest of the way across the bar and physically throw him out into the street.
Go ahead.
So watching the video, though, it looks like after he kind of pushed him towards, I can't remember which of the two, he didn't continue to assault him. Yes, he took him to the door and kind of pushed him out the door, but it didn't, does that make a difference? If
Yes.
hypothetically we were to determine that there was no assault that took place after the manager handed him over, what does that mean?
So if no assault took place after the manager handed him over, it certainly doesn't change the manager's behavior in facilitating this assault by physically handing him over. It may go to damages to say, listen, if he didn't continue to be hit or kicked, was he hurt after the manager handed him over? That's, like I said, a question that that goes to damages, not to liability itself.
Okay, thank you.
And you're out of time. Thank you.
Good morning again, Your Honors. May it please the Court. Just want to sort of briefly address there are a lot of factual issues in this thing, but I think that a fair reading of the record indicates that these just do not establish that they are acting, that Caleb or Forehead are acting as agents. And
But is it about establishing, or is it about taking the evidence in the light most favorable to the non-moving party?
well, I think
Because
that,
basically, the question is there evidence? You know, if there is no evidence to take in the light most favorable to the non-moving party, then clearly summary judgment being granted is proper, right?
correct.
So the question that I would have is, how is it that there is, you know, you're saying there's no evidence? I think that you would need to address that statement that's in the entry by the judge.
That is, and I did find that interesting, Your Honor. But the court does say, plaintiff again tried to attack Bales, and Julie grabbed him by the collar from behind and handed him to Caleb so that Caleb could eject him from the bar.
And that's,
that is sort of,
it's a very interesting statement.
it is interesting, and that is the court speaking, and the only other person that is, the person that is acting there, is Dante and Julie, the manager that was on duty at the time, who was called by the bartender to come to his assistance. The bartender was doing what he was supposed to. And Julie doesn't his testimony is different from what the trial court said. So this is on page, this is the Anjuli deposition on page 14, lines 12 to 23. And Julie says, and I grabbed him by the shirt. I said, you need to leave, stop. And he grabbed me, meaning Caleb, grabbed him. And that's when one of the other gentlemen just grabbed him and sorry, I got the people mixed up for a second. And Julie says, you need to leave, stop, and he grabbed me. That's Clark grabbing him. And that's when one of the other gentlemen, and this is Caleb, just grabbed him and threw him out the door. Okay, when you say one of the other gentlemen, was this an employee of Martino's or someone else? Someone else, I have no clue who it was. He was just trying to help me because Mr. Clark hit me by the shirt and he was very angry. So
I think what it comes down to is, what does the video show? Because the video shows what it shows.
the video shows what it shows.
And when I looked at the video, it was consistent with that entry of the trial court, as far as what took place, as far as the acts.
The video does show what it shows, but I think that we need to, if we're trying to determine whether or not this is an agent, we need to look at what the manager thinks about this person. And the manager is saying, I don't know who this person is. If he were an agent, this is a little family business. There's the father, Marty, there's Dante, his son. Dante's there all the time. Dante is very solicitous of his father.
It's only those people. Did one of the employees say that the manager had introduced him, or that there was a nickname or something to that effect for one of these that tied it back to the manager?
I cannot remember that part, Your Honor.
Yeah.
I can't.
Counsel, are you suggesting that Dante's explanation in his deposition explains why he might have taken Mr. Clark and passed him off, as the trial court described it?
Well, I think that this was a scuffle where there were numerous people there. He's trying to get him to the door. Somebody else is doing that, and it's immediately after that point, if you remember, that the plaintiff, Alex Clark, then runs over to the bartender, who's just to his right, and starts getting him, and then the manager has to go over and pull Alex Clark off of him and again try to get him out. So it's it's a fluid situation, but,
So
you know.
his explanation kind of fleshes out his actions in the video by explaining that he wasn't doing this
Well, I think it does
as
two.
an employee agent situation, but just because here was someone available to help me.
Yes, I think that he doesn't know who he is, and, I mean, and all of them emphasize the other bartender on duty didn't know Caleb and Forehead. Dante didn't know them, again, he saw them.
Well, it's clear that Mr. Bales did. Mr. Bales knew
That is-
Caleb and Forehead,
Yes,
and he knew them for quite some time.
yes. He had seen them
And-
numerous times in the bar.
And it appears from the testimony of Mr. Bales that at least one of them, I can't recall if it's Caleb or Forehead, had expressed an interest in working there. And Mr. Bales had said, you need to go talk to Dante.
Right, right.
Does any
But-
of that equate to an employee or agency relationship?
No, no, I mean, that's just somebody, it's like, maybe I could work here, maybe something like that, but nothing ever indicates that it went any further than that. That there was actually some type of agency deal, some type of interaction between the management that would turn them into the agents. And we don't have the bartender even acting as if they are agents. He may have said that they had come to him, they were interested in a job, but there are no actions that I'm aware of in the record that indicates that they did actually have any authority, that anybody had passed that to them.
Well, didn't he say that, Mr. Bales, the bartender, didn't he say in his deposition that they were there that night as his friends and that he did not have any reason to think that they were employees that night? Isn't that what he said?
I thought he was speaking more generally, that he just didn't know that. And he said, that's where he said that's a Dante question, and you have to ask him. He also said, I never saw them get paid. He never identified them as employees, or I don't see there's any other time where he identified them as having some kind of authority to act within the bar. They're just sitting there, it seems to me.
I noticed that the video seems to be just a portion of the entirety of what happened.
Yes, Your Honor.
Why was there a truncated video presented?
That is apparently what was saved by the bar, and there was a motion, a spoliation motion that was brought in the lower court, the court in the same motion where it decided the summary judgment said that this is moot because the summary judgment applies here and we're not going to consider it. And you said, but even if we were, the portion that was saved was that portion which goes exactly to the fight, and so it shows that.
I mean,
That
the one
issue was
thing-
not appealed.
The one thing that it doesn't show is the moments before, so that the trier of fact, if there is a trier of fact, or for summary judgment and taking a light more favorable to the non-moving party, to know whether there was a signaling that took place. Because if there was a signaling that took place, that would have taken place before the video began.
It would have. I don't know that it would have indicated it, because whatever it was that Alex Bale did that made Mr. Clark think that he was signaling him, the video doesn't show the people at the bar.
Mm-hmm.
It looks out into the bar room, so I don't think that would have been visible. But there may have been other things that it could have indicated. But there is ample testimony in the record from everybody else as to what happened. So it's just something that we don't have, Your Honor. So I've got a little bit of time left.
So let me ask you this. So there's testimony, there's depositions, there's statements that Caleb and Forehead are not, and I'm going to put it in air quotes, employees of the bar, okay? And the position of the appellants is that there's circumstantial evidence that shows otherwise, right?
That is the position.
Okay.
Yes.
So explain to me why that would not survive summary judgment if there's circumstantial evidence. Why would a statement be dispositive of whether these two individuals were acting under some agency, some sort of higher, some sort of expectation, some sort of control on that evening?
Because if you look at all the circumstances that are here before the court, there's very direct evidence as to their not being agents.
Well, there's statements, and they're basically self-serving statements. What's the direct evidence?
Well, Your Honor, I mean, there were requests for admissions where it was denied that they were employees, where it was denied that they were ever paid by the bar. They're not wearing the kind of attire that the actual bouncers and other employees wear, which is either a black shirt, and the video very clearly shows that Caleb and Forehead are there there's a white shirt and a red lanyard on Forehead. Caleb has this red shirt.
I have to go back and comb through it, but I thought that the evidence was about employees usually wore black. It didn't address bouncers. And this is where it makes employees a very interesting term of art, because the bouncers are not paid, on payroll, and in fact,
Correct.
one of the bartenders or so can't even identify who's a bouncer because he says that they're not even paid in front of the servers or the bartenders. So looking at that evidence, or looking at that statement about the black shirts, it said, I think, employees and bartenders, something like that. And so it might be accurate, but not applicable
Well, in
to
this
bouncers.
in this case, Alex Clark testified in his deposition that he talks about the bouncer being at the
He
door.
talks about
two
when he
separate
entered, there
portions.
was
And
a
the
bouncer
second
with a
one,
black, yes.
He says that he's wearing a black shirt.
Correct. And so, looking at the light most favorable, right, to the non-moving,
Right.
that just means that bouncer's we know the bouncer's not there,
Right, but
because there's whole testimony that that bouncer was gone.
Right. But, I mean, when you look at the evidence that they have, what they call the evidence, I mean, there are a couple things.
And I'm not trying to assert this is a clear case. If it went to the trier of fact, it would be interesting to see what happens.
Right.
But I think that at the end of the day, I'm trying to figure out, circumstantial evidence. You've got a statement that's self-serving statements, because this isn't a case where you can say, here are the employment records, and you have direct evidence. Or here's this person used to work here, this is the date of termination, right? So you've got statements, you've got some circumstantial evidence.
Well, the
what do we-
circumstance, to me, it doesn't even rise to the level of circumstantial evidence. That it's rather speculation. Alex Clark said that he saw some kind of motion. So we don't have that. There's no testimony by Mr. Bales.
But we take that in the light most favorable to the non-moving party, don't we? Or do we just discount that?
Your Honor, I think that a motion can be so many different things that it's not.
No, but let's talk about that specifically.
Okay.
These are the things that I'm trying to figure out, honestly.
Sure.
I don't think that there's a clear path on this one, right? So, the plaintiff's statement is that there was a signal. Do we take that in the light most favorable to the non-moving party, or do we totally discount that?
He didn't say it was a signal. He said that he motioned.
Okay,
he
so
gestured.
what do we do with that statement of the gesture?
I think that you cannot say that means go talk to my agent over there. There's nothing else that backs up the bartender having established some sort of relationship with those people as people that handle things. When a problem arises with Clark,
I think
he
I
goes
agree.
to the
I can
manager.
agree with you that that alone doesn't, but, we certainly don't say it didn't happen. We would say, okay, there was a signal. He says there was a signal. All right, so that's one thing.
But again, a signal is a verb that puts meaning into an action, whereas I thought the testimony that Clark said was it's a motion.
Okay.
He motioned to these people. It's some kind of
Right.
body thing.
Counsel, I have a further question for you,
Yes,
and
sir.
then you're at the expiration
Okay.
of your time. So even if we take into account Mr. Clark's testimony that there was a signal, a gesture, a motion, whatever we define it to be, does the bartender have managerial authority on this record to create an agency relationship between the bar and Caleb and Forehead?
No, he does not have that authority. And in fact, he said, I don't know, that's a Dante question. He sort of eschews any kind of authority.
So, when you say that's a Dante question, as I understood it, he was saying that any hiring was a Dante question,
Yes.
correct? Okay, I just wanted to clarify.
But, yes, but hiring with regard to not just bartenders, but bouncers.
Right, okay, thank you.
Thank you, Your Honors.
Thank you.
Thank you for answering my questions.
I'm sorry.
Thank you for answering my questions.
Not at all.
Your Honors, I want to make sure that I point out three specific pieces of evidence that haven't been discussed here, that are circumstantial evidence that would lead one to believe that these people are indeed bouncers, employees of the bar, agents of the bar at very least. One of them is
Well, I
that
don't know that we have to be led to believe that they were agents. I think it's that they could be agents.
that they could be agents, yes. One of them is that although when you watch the video, their behavior is the one that's brutal. They're the one who's kicking someone while he's down and punching him, yet they're not the one who got thrown out of the bar. That's consistent with a belief from Dante or from the bartender or whoever.
Well, that's an interesting point, because at the end of the day, what Clark did was push the manager.
He
And
did.
while there's an audible sound, he pushed the manager.
Yes. However,
Not the manager, the bartender,
he smacked his hand away.
or something, yeah.
He did indeed smack his hand away. However, it's a smacking his hand away versus these people are violent. I don't know that there's much disagreement that these people, that these two, Caleb and Forehead, are violent. They're kicking him while he's down. Caleb is standing right next to the door when he throws Alex out.
I want to make sure you get to your other two facts. So
Okay.
what are the other two?
The other two, one of them is that Bales testified that they weren't customers. They didn't order drinks. They didn't order food. So it begs the question what they're doing there if they're not customers and they're not employees. With regard to the, I apologize, this actually isn't a factual point. This is something that was brought up during the defendant's or appellee's argument, pointing out that, quote, this is the court speaking when we're disagreeing with some conclusions that the court came up with. And I believe, Your Honor, pointed out that there really is no clear path on this, which I think is indicative of not granting summary judgment. I mean, if the facts could go either way, then this isn't a summary judgment question. This is something that should be resolved by the trier of fact, who can look at these people and say, yes, that statement's self-serving, but it's also consistent with two other things that happened or whatever. because it is no clear path, I would submit that that's exactly why this isn't a summary judgment question.
Thank you.
Thank you.
Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision. Enjoy the rest of your day.
All rise. The Court of Appeals, First Appellate District of Ohio is now adjourned.
It was very nice to meet you in person.
Thank you. Nice to meet you. Nice job.
And thank you, you as well. And I think I say over and over again,